afternoon, ma'am. Welcome to this webinar, ma'am. Thank you so much for joining us.
Thank you. Sorry, I got a bit late in
No, not at all. On the contrary.
You are on time. You are on time.
Not on time, if at all, 1 minute earlier.
1 minute earlier.
Still 4:29. Now 4:30. So not late.
So, do we have the permission to start, sir? Shall we start?
Please,
or we should...
please do start.
Okay. Thank you so much, sir. Good afternoon to all our dear delegates and esteemed panelists, and obviously above all our keynote speaker for the day, Ms. Jyoti, Jindgar, Secretary, Independent Charge, Competition Commission of India. Thank you, ma'am, for joining us. Thank you once again for accepting our invitation and joining us for the webinar. You know, ma'am, PH Chamber has a very dedicated committee on competition law and consumer affairs, which is actually headed by another Mr. Dhanendra Kumar ji. And he has been guiding us throughout this whole year, and he'll be guiding us further also. And it is being co-chaired by Mr. Vivek Agarwal. Vivek ji, thank you so much for joining, making it possible. And thank you, ma'am, once again. I would like to, for the information and knowledge of our delegates, esteemed delegates who have joined, we would just like to read a brief profile of ma'am, our keynote speaker for the day. Ms. Jyoti Jindgar, the Independent Secretary, Independent Charge Competition Commission of India, holds a bachelor degree in economics as well as master's degree in business economics from Delhi University. She possesses a vast regulatory and enforcement experience and has been a part of various domestic and international committees and think tanks. She is presently the Secretary of Competition Commission of India and also heads one of the antitrust divisions at Competition Commission of India. She has been actively involved in various policy matters and also initiatives undertaken by CCI during COVID-19 to ensure a smooth functioning. Before her current role as Competition Commission of India, she worked as an additional Director General for about 5 years in the Office of the Director General Competition Commission of India. As in charge of one of the investigation units, she conducted investigation into various and alleged anti-competitive activities such as cartels, bid rigging, vertical restraints, and abuse of dominance, including those in new age technology markets. Earlier, she also worked for about 15 years in SEBI, the regulator for the securities markets in India, in various capacities in multifarious areas. She has a vast global exposure and has represented CCI in various international conferences, discussions, and workshops. Just a brief profile, ma'am, of your vast experience which you possess. Thank you so much. We would like to begin, before beginning, we would like to just elaborate a little bit about PhD Chamber of Commerce and Industry, which is a national apex chamber for the last 170 years. And it's a forward-looking a catalyst organization for the promotion of Indian trade and industry. It is a forward-looking, dynamic pan-India organization which has presence across the states. More than 17 states we have offices, and we have presence across the world also with MOUs with number of international chambers also. And we have been working especially for the grassroots level development, especially for promotion of the MSMEs. And that's why today's webinar, which is very important, meaningful, and timely webinar, holds more importance for the MSMEs actually to safeguard their interest in the business world. Recently, as we all know that in the beginning of August, the MOS Corporate Affairs actually introduced this competition amendment bill on around, I think, 5th of August. This bill becomes very important in present context because competition policy seeks to actually create a space in which all the domestic and foreign firms compete equally. A competitive market will ensure that the consumers get quality goods at a competitive price. It will also provide incentives to producers to innovate and enhance efficiency and productivity. This will obviously ultimately help achieve higher economic growth with efficiency and equality. The Competition Amendment Act is a tool to implement and enforce competition policy to prevent and punish anti-competitive business practices by firms and unnecessary government interference in the market. It is equally applicable on written as well as oral arrangements between the enterprises. So we have the need is actually to promote the new age market on the issue of acquisition, and actually to create a hub and spoke arrangement is a kind of catalyzation in which vertically related pairs act as a hub and place horizontal restrictions on suppliers or retailers. So these all needs to be addressed. At present, the prohibition on anti-competitive agreements only covers entities similar to these that engage in anti-competitive practices. This ignores hub and spoke cartels operated at different levels on the vertical chain by distributors and suppliers. Talking about the way forward with new changes, the Commission should maybe be better able to manage certain aspects of new age market and make its operation more robust. So with this, I think just a small context. Obviously, our chair of the committee would certainly set the tone of the whole discussion. We would once again thank our keynote speaker and chair and co-chair for the day to join us and take this webinar forward. Thank you so much. Now I would like to invite Shri Dhanendra Kumar ji, the chair of the Competition Law and Consumer Affairs Committee, PHDCCI, and the former chairman, the chairman of the Competition Advisory Services, to kindly present his welcome address for the day. Over to Dhanendra Kumar ji. Ravi, I think sir is not able to speak, or
I think sir must have a connection problem. His
if you can
video
just
actually
check with
jammed.
him.
I'll just call.
There's a connection issue today also at our office. We have been facing this connection issue since morning, ma'am, and we haven't been somehow some time back we actually managed to rectify the problem. There was a server down since morning. I think sir may have been facing the same problem.
No problem. I think by now we all are familiar with these.
Familiar. So now things,
problems.
as the things are opening up, ma'am, so I think more and more people are going physical. But now we have actually we are working on a hybrid mode. So it's equally important that we remain digital
Yes,
also.
online connectivity.
It becomes so convenient, ma'am, for us.
So Dhanendra Kumar sir is rejoining in a 1 minute.
Sure. In the meantime, ma'am, Vivek Agarwal ji is our co-chair, and he's also been guiding us on this. I think he also met you, if you remember, at your office.
Yes, of course.
Yeah. So he'll also be actually addressing on the issue of competition amendment bill once our chair and obviously you speak. So he'll be taking. Vivek ji, would you like to share some remark?
No, I've been working with Jyoti ma'am at least since 2011. I remember right from the DG days, and it's always been not just a pleasure working with ma'am, but it's always been a tremendous learning experience right from the DG office when I was a young lawyer back then. And I remember I used to come for some of those cases, and I have actually in the last over a decade now actually continuously learned a lot working closely with ma'am in multiple capacities, and just looking forward to hearing from ma'am in terms of what's her thoughts on the proposed amendments are, and just looking forward.
No, I think it has been a wonderful journey for everybody who has been attached with the competition law. And I personally feel that PhD Chambers is doing an excellent job, particularly in the context of reaching out to the grassroots level and disseminating on competition law. And I think today's seminar and this is also going to play a very important role in reaching out to stakeholders and explaining the objectives and some of the key proposals.
I'm truly grateful for the support we have got from the Commission, ma'am, throughout our term for last 1 year. We've been extremely.
Advocacy is a very important aspect of our functioning. And we really value our association with all the industry chambers, and there we can see Mr. Dhanendra Kumar.
I think sir has joined.
Apologies for this technical glitch. So first of all,
So welcome back, sir.
So,
yes, am I audible? Am I visible?
Very much, sir.
Okay. Thank you so much, Jyoti. It is such a pleasure having you with us, and many thanks for for positively responding to our invitation. Miss Jyoti Jindgar and I have been old colleagues ever since the day I began my journey in the Competition Commission, and she was a very bright colleague of ours at that time. Later on, she did exceedingly well in the Directorate General of CCI and subsequently Advisor Law. She is one of the most knowledgeable persons in the competition law, and therefore it was a privilege. Thank you so much. It was a privilege for us to invite her, and I am so grateful that she readily responded and immediately agreed, despite the fact that these days she is extremely busy, I know, and probably leaving the office till late in the night. So many thanks for your
it's a privilege, sir, to be here with you.
Thank you so much. I would not like to dwell too much on the Competition Law Amendment Bill for the simple reason that we are waiting to hear Ms. Jyoti Jindgar on this, but I'll quickly lay the ground for the discussion. Competition law is one of the most important legislation today for doing business in India. It was formed in 2002 and amended in 2007. Much water has flown under the bridge ever since. In fact, I happened to be appointed as the chairman of the committee to draft amendments in the competition law in 2012. And we made certain recommendations, but it couldn't see the light of the day at that time. Later on, a committee was formed under the chairmanship of Mr. Injeti Srinivas, the secretary of Ministry of Corporate Affairs at that time. And the recommendations are comprehensive and they are in public domain. And a competition law amendment bill was drafted at that time, amendment bill of 2020, and submitted to the parliament. However, it could not be finalized. Now, today, we are at a stage when a comprehensive competition law amendment bill 2022, an extremely important piece of amendment legislation, has been introduced in the parliament, suggesting significant changes to the competition law. The main objective of this bill is to speed up decisions by the CCI, make its functioning more effective and robust, fast-track M&A clearances, work towards greater sense of ease of doing business and transparency. The new regime is supposed to be trust-based, so timelines are reduced with deterrent punishment for submission of false information. So it's a paradigm shift in the administration of competition law. We should be in the interest of business, doing business honestly and transparently. The bill has been submitted, referred to the Standing Committee of Parliament for Finance, headed by Mr. Jayant Sinha. It is expected that this will be brought up before the winter session of the Parliament. While the details would be outlined by Ms. Jyoti Jindgar, I would very quickly, in a couple of minutes, like to, just for the sake of sparking off some discussion, some of the key features of this amendment bill. One, as I said, it is to fast-track decision-making. Single member from the erstwhile 6-member board is can decide cases of adjudication, not key functions of CCI under the provision of the new act. With earlier the quorum was 3, now it could possibly be a single member also. Then one of the key features would be provision of settlement and commitment, settlement before submission of DG's report and commitment after submission of DG's report, but before orders of CCI, which may involve payment and commitment, and this could cover a whole lot of ground. This has been extremely important because the intention of the law is to make changes to make corrections in the market behavior and not exactly punish or impose penalty. And Ms. Jindgar would know better, but I believe there are about 17,000 crores worth of fines imposed, but the actual recovery is not even 1%. And the matter is generally stuck in courts High Court, Supreme Court, and NCLAT, and so on. And the result is that precious time and energy is wasted of everyone, the stakeholders and the CCI. Then review of the global M&As above a certain value, having substantial nexus, business nexus in CCI, in government in India, slashing the time limit of approval of M&As from 210 days to 150 days, increase penalties for false information from 1 crore to 5 crore, making DG a part of CCI, expansion of DG's powers, and a new threshold of control with certain features which would include ability to exercise material influence. This would be a lower threshold, but we'll have to define exercise of material influence, and expanding powers of granting leniency, provision enabling parties to call expert, 25% pre-deposit of penalty on appeal, and transparency in making regulations. We do not know what will be the final shape of things after the bill is received from the Standing Committee of the Parliament and placed for consideration of the House. So until then, this is the picture before us. And it would be extremely relevant for us in the PhD chamber to know how it is going to function, how it is going to affect life. And PhD chamber, Jyoti, I may also mention, is one of the most important chambers in the country, business chambers, for many reasons, including the fact that I know their secretariat is one of the strongest I've seen anywhere. And they do conduct research on various issues very professionally and come up with practical solutions. So I have a lot of respect for their professionals. So with these words, I thank you once again for responding to our request. And I also thank the participants. I can see now there are 52 participants, and the number is constantly increasing. So I thank them for joining us, and I hope that they take away the discussions and the key points from this for their benefit. Thank you very much. May I request you to kindly enlighten us on the provisions of the bill?
Thank you, sir. Thank you. Thank you so much for actually setting the tone for this whole discussion. Now we would request, as you already formally requested, ma'am, to kindly enlighten us with her thoughts on the subject. Over to you, ma'am.
Thank you so much. So at the outset, I thank PhD Chambers for giving me this opportunity. And as I mentioned earlier, PhD Chambers has really been doing an excellent job of spreading awareness about the nuances of competition law at the level, and which is so critical for a country of the size and breadth like ours. And indeed, it's a privilege for me to be here with Mr. Dhanendra Kumar, and I happen to have started my career under his chairmanship in CCI, and he has been such a guiding force for the competition law all along. So before I talk about the proposed amendments, I think it is very important to understand the context. So for any economic law to serve the intended purpose effectively, it is very important that its framework is in sync with the underlying economic fundamentals. And if you look at the journey of evolution of competition law in India, it has also closely followed its state of economy. For like MRTP Act, which was the nascent form of competition law in India, was drafted keeping in mind a control and command closed economy, and as such frowned upon monopolies. So it was serving what was required at that point of time for the given state of economy. But the financial and economic policies of India went through a significant change post-liberty in 1991. And the cornerstone of these reforms was the recognition of markets as a facilitator of economic growth. So MRTP lost its relevance, and a need was felt to have a modern competition law based on best international practices to cater to demands of a liberalized and globalized economy. And in this backdrop, the Competition Act was enacted by the Parliament based on recommendations of the Raghavan Committee. Now, during this period, I think all would agree that CCI has been able to establish itself as a mature regulator through its nuanced and targeted enforcement actions. And even on merger side control, CCI has remained steadfast in promoting inorganic growth through fast adherences of deals, at the same time addressing anti-competitive aberrations through modifications. And it has contributed towards the development of competition and fair play markets. But there has been a significant growth of Indian markets in the last decade and a paradigm shift in the way businesses operate, they interact with the market, and there has been this emergence of new markets which are driven by technology. So although even the existing competition law is robust, however, there is a need was felt to basically have a relook, and in order to draw from the past experience and to prepare for future challenges in the enforcement competition law framework in India, the committee was set up by Ministry of Corporate Affairs, about which Mr. Dhanendra Kumar ji has already mentioned. And based on this extensive deliberations, they gave their report and suggested forward-looking recommendations taking account new age indicators of business activity. And as a follow-up action, the now bill has been introduced and it has since been referred to the Parliament Standing Committee on Finance. Now, this was a bit about the context and the background to the present amendment bill. Now, if you see, the bill is quite wide-ranging in its sweep in terms of the procedural and substantive amendments, and also the proposed amendments cut across all the functions of CCI, be it enforcement, regulation of mergers, or its advocacy mandate. So it is a very comprehensive, holistic assessment of the functioning, based on the functioning of CCI, the experience gained, and the extensive consultation on the stakeholders. But the common underlying principle, I think, which very clearly emerges, is being able to facilitate ease of doing business by providing regulatory certainty, introduction of framework for faster market correction, and a trust-based business environment. And you will see this thread across all the amendments which have been proposed. And in fact, I must mention here that many of the proposed changes are in fact refinements, in the sense that they propose to explicitly capture and incorporate what has been the decisional practice of over the years. For instance, the proposal that economic activities of enterprises will be subject to competition law is in line with the interpretation of CCI, but this has been an area of challenge in several cases. So once explicitly incorporated in law, it will, I think, settle this issue once for all and prevent repeated reference to the judicial fora for basically looking into this aspect, and will go a long way in avoiding uncertainty over the scope of the law, and would provide guidance to stakeholders covered under it. On the enforcement side, the bill moves broadening the scope of anti-competitive agreements by explicitly including within its remit agreements that are not in the nature of horizontal or vertical agreements. So this is not to say that till now CCI could have looked only at horizontal and vertical agreements. As per the extant practice, CCI has been capturing such agreements and arrangements by invoking Section 3(1) of the Competition Act that forbids anti-competitive agreements. But this also has been a subject matter of challenge. So the proposal will have important implications for addressing issues in new age markets where novel business arrangements are entered in multi-sided platform ecosystems, and it will do away the need for a reference to a judicial review of this issue. The bill also proposes to include active facilitators of certain anti-competitive agreements within the framework of law. As was mentioned, it will cover hub and spoke cartels, that is where the anti-competitive agreement between players at horizontal level is facilitated through a common vertical player. And this is an important development considering increasing likelihood of such arrangements in new age business models. The bill seeks to introduce settlement and commitment framework to reduce litigation. The settlement mechanism is sought to be applied to alleged contraventions related to certain anti-competitive agreements and abuse of dominance. So cartels, being the most pernicious form of anti-competitive agreements, have been presently kept out of this framework. An application for settlement may be filed only after the receipt of investigation report, but prior to such time as may be prescribed by regulations. So that the entire facts and circumstances are before the commission and also the parties before they approach the commission for a settlement. And before passing the final order, CCI can impose certain conditions, may also include a settlement amount. Apart from that, the bill also empowers CCI to accept commitments from from parties to address anti-competitive concerns which have been raised in any information. And this, as envisaged in the bill, an application for commitment may be made only after an inquiry has been initiated by CCI, which means that 26(1) order has been passed so that it crystallizes that what are the prima facie concerns which have been raised, however, prior to receipt of investigation report by the party concerned. So a lot of discussion and I think thinking has gone in basically proposed mechanisms so that they have adequate safeguards. At the same time, they allow the parties to assess the situation and come out with their proposals. And definitely this is a very forward looking relevant proposal, because the regulatory processes and procedures in the present framework involve detailed investigation, inquiry, followed by a two-tiered appellate avenues. And this necessarily involves significant time and resources. So if adopted, these mechanisms will equip CCI to ensure speedy resolution of cases. In fact, this is an extension of a trust-based solutions or a framework. And we already have a framework in the form of lesser penalty for reporting of cartels, self-reporting of cartels. And in that sense, it is an extension of that trust-based solutions that the Act seeks to provide for. Now, talking about cartels, these are usually hashed in secrecy and recognized as most egregious violation of competition law. And our experience of enforcing leniency regime so far has been encouraging, and it has helped uncovering cartels through this route. So I think recognizing this, the bill seeks to extend this regime further and by introducing leniency plus framework and even permitting withdrawal of leniency application. So I think this is a recognition of how the existing leniency scheme has worked well. The parties have also responded, and they have, I think, been able to kind of justify the suitability and the relevance of this mechanism. And just to explain, leniency plus is a proactive antitrust enforcement strategy which is aimed at attracting leniency applications by encouraging companies which are already under investigation for one cartel to report other cartels unknown to the competition regulator. Because what experience has shown is that when a cartel gets uncovered or an enterprise gets to know about it, then they may do a lot of due diligence and they may kind of check the compliances, which may uncover other cartels. So it was felt that it is very important to incentivize such enterprises who would want to self-report to further incentivize, and therefore this mechanism is being proposed. And this also, this mechanism already exists in many jurisdictions like UK, US, Singapore, and Brazil, and will further. So here, the measure will involve reduction in penalty in the first cartel to the person disclosing the information without prejudice to the company obtaining lesser penalty regarding the newly disclosed cartel. So an additional bonus in that sense for the first cartel for disclosing the second cartel, which will be in addition to the existing discounts which are available within the total within the basically the various slabs that we have. And we really hope that if adopted, this proposed framework would further incentivize applicants to come forward regarding multiple cartels, thereby enabling CCI to save precious time and resources on cartel investigation, and will result in faster market corrections. Here it is also important to mention that a limitation period of 3 years has been provided for filing information and reference before CCI for anti-competitive agreements and abuse of dominant position. Now, the competition law enforcement has been around for over 13 years. And we have observed that sometimes the information providers bring cases before CCI in respect of agreements or cause of action, which dates really back in time, and at times even before the act got basically notified in 2009. So this creates a lot of uncertainty and puts businesses on a perpetual risk of being dragged to CCI. So businesses and markets would thus get much needed certainty, which is a sine qua non for ease of doing business if this proposal gets accepted. Now, let me talk a bit about the proposals relating to the merger control regime. And in fact, there are quite a few of these amendments, which I think will further carry forward the CCI's record of basically facilitating mergers with technologies, at the same time carrying out corrections wherever required. And so mergers and acquisitions are very vital for evolution and restructuring. Nevertheless, the experience has shown that they can change the market structures by increasing concentration of resources, and they can result in unfair pricing, poor quality of goods and services, and distortion of level playing field. So mergers and acquisition is really a fine balancing of facility and enforcement function of competition agencies. And these proposals also, I think, further need to assist CCI in striking then that balance, and are based on a foundation of a trust-based system that facilitates synergetic combinations while adequately addressing any potential anti-competitive harm to competition. So one of the very significant proposal, I think, which has come up is in the form of reduction of overall time limit for approval of MAs from 210 days to 150 days. And in fact, they obligate CCI to form a prima facie view within 20 days of receipt of notice. Of course, these are very tight timelines. However, overall, I would say that these proposed changes are in alignment and in sync with the regulatory practice and philosophy of CCI in facilitating inorganic growth of businesses. In fact, the introduction of the green channel for automatic approval of combinations, which was done in August 19, has been also now also included officially in this amendment bill. And this is the first of its kind where transactions get automatically deemed approved on the day of filing. And today, nearly 30% of the filings are under green channel, which demonstrates the success of the initiative. And recognizing then that, I think the bill seeks to bring this mechanism in the act itself. Of course, the underlying assumption for all these changes and a trust-based regime to succeed is that the parties will reciprocate by providing complete and full disclosures. Analogously, making of false statements or omission of to furnish material information will now attract aggravated penalties, as has been proposed in the recent amendment bill, apart from other consequences. So again, this is an attempt of providing incentives, at the same time having deterrents for which are very much required for any trust-based system to function. Now, let me talk about a very, very significant proposal, which is the introduction of a deal value threshold of rupees 2,000 crore as an additional criteria for notifying mergers and acquisitions if the target has significant business operations in India. So every word of this is very, very critical. Outset, although normally I think it is being understood in the context of digital markets, but I would like to mention here that the provision is agnostic in nature and not specifically catering only to the digital ecosystem alone, although it may have, having said that, it is particularly significant in the context of new age markets, where factors such as users, data, growth, and network effect have become means of gaining significant market position. Entities operating a significant business model in new age business command significant valuation, but they may have significant assets and no or insignificant turnover recorded in their financial statements. Now, presently, jurisdiction of CCI is limited only to mergers and acquisition transactions that meet the asset turnover thresholds specified in the law. It is now widely recognized that these traditional asset turnover criteria may fail to capture potential anti-competitive transactions in new age markets, and as a result, where acquisitions where entities generate little or no turnover are purchased at a high price may need examination from a competition law standpoint. Now, different jurisdictions have responded differently to basically plug this gap. Germany and Australia, through legislative changes, have introduced new transaction value thresholds like the one which is now sought to be introduced. US already had it. In other jurisdictions which are not captured through traditional asset and turnover based criteria, now they are being examined ex post, post consummation of transaction, which is of course very debatable in the sense that it may involve a huge cost if at some point of time it has to be reversed. Now, the attendant requirement of significant business operations in India, which is I mentioned for this threshold to trigger, is meant to exclude M&A transactions where the target exclusively operates abroad or has limited business operations in India. Local nexus is a very important criteria, even for the existing thresholds which are based on asset and turnover, and we have de minimis there as well. And the locus nexus criteria for this purpose is likely to be based on factors that affect valuation of an entity in new age markets. These would be largely based on market-facing factors such as number of users, number of contracts, aggregate amount of payment received, etc., of the target that are not completely reflected in assets as recorded in financial statements, because this is given that what this threshold seeks to address. So obviously the factors will have to be in sync with that, and it is felt that if adopted, it will provide the flexibility to dynamically respond to changing market conditions. Now, another key reform which is envisaged in the bill is to do, in the context of the merger, is to do away with the requirement of prior approval of CCI in case of transactions involving open offer or acquisition of shares through regulated stock exchange. And I think this has been a very long demand of the industry, because presently the parties to M&As are required to notify and wait for a period till the approval they get from the commission. And in case of market purchases where prices are volatile, if a person is required to wait for approval, it may lose the opportunity to buy the shares at the best prices. And also, if the information to an acquisition of shares is made public, that by itself may result in speculation and adversely affect the viability of these transactions. Therefore, time taken for the competition assessment and approval may increase the cost of transactions. So to address the above eventualities and in line with the international best practices, the proposed amendments seek to establish a special framework for market purchases. In this framework, parties can conduct market purchases, notification and approval of CCI. However, subsequently, they would be required to notify to CCI within the specified time, and they shall not exercise any ownership or beneficial rights or interest in such shares till its approval. I think this is again a very, very classy attempt to strike a balance, between seemingly conflicting considerations. And thus, it will balance the need of standstill requirement and the compelling element of time sensitivity in market purchase is a major step towards ease of doing business. Again, threshold of control as the ability to exercise material influence in any manner over the management of affairs or strategic commercial decisions has been proposed in the bill, and now this material influence may arise through factors such as representation on the board of target, contractually agreed consultation, veto rights, voting percentage held by the acquirer. So here I must mention that in fact this proposal is actually in line with the existing CCI's decisional practice and therefore does not actually practically change any parameters, would not practically change the basically framework if this is adopted. And therefore this again change is aimed to bring more clarity and certainty by clearly specifying the control threshold in the Competition Act itself, which has been a subject matter of debate. And it is expected that it will make the stakeholders more aware of their obligations and prevent any unintended non-compliance. Now, for an overarching market regulator like CCI, which has interfaced with various regulators, interregulatory references are very critical, and the bill recognizes that. While even the existing framework provides for this framework, but the amendments seek to expand these kind of mechanism and bring down the threat for such triggering of these mechanisms. And as such, it will engender a committee among regulators, would obviate unnecessary gaps and overlaps between regulators, reduce regulatory arbitrage, and would result in a cohesive and holistic enforcement, providing much needed certainty and predictability to the businesses. In fact, the bill also enables CCI to enter into MOUs with sectoral regulators, institutionalize the interregulatory consultation between CCI and sectoral regulators. And lastly, recognizing the importance and criticality of advocacy in the context of a country like India, where legacy issues still persist. The bill has basically required CCI to work towards developing a culture of competition, I think, which is again a very strong, philosophical, forward-looking, positive, I think, direction which the bill provides. So these are some of the salient proposals of the amendment bill, which to my mind will go a long way in strengthening CCI to ensure that the markets remain competitive and innovative and will facilitate growth. Of course, what it will be the final shape would depend now on what happens before the standing committee, and of course seeks suggestions from the stakeholders. But having said that, this is of course our take on this, and of course these are my personal views and may not necessarily represent those of CCI. Thank you so much for giving me this opportunity.
Thank you. Thank you so much. It was so clear and so crisp and very detailed. So, Nasir, over to you. You may like to request.
Thank you so much, ma'am. Sir, you have already mentioned, and it was so detailed, and I think a lot of apprehensions which were there in the minds of the participating companies. It must have been cleared, ma'am. So comprehensive, every aspect of competition amendment bill, and I think this is very enlightening. Thank you so much. Sir, would you like to add anything, sir? Dhanendra Kumar, sir?
Well, thank you so much, Nasir. I don't think I should try to expand whatever has been said by Jindgar. It is absolutely clear what she has done. I would only like to say that it will be very useful if a script of what she has said today, at least in the beginning, a recording, and maybe in due course a script is circulated to the members. It will be very useful to them. Today, those who have listened to her, it's quite clear. And now Mr. Vivek Agarwal can elucidate on some of the issues. Thank you so much, Nasir.
Thank you, sir. To Vivek Agarwal ji, our co-chair for the competition committee and consumer affairs committee and the DMB advocates. Vivek ji.
Thank you. Thank you so much, Dhanendra sir. Thank you so much, Jyoti ma'am, for such an enlightening address. And I don't need to repeat that it was very clear and very detailed. So truly grateful for a very helpful address. And let me just, open my remarks. I'm keeping an eye on the clock as well, and I know I am a little pressed, so I'm going to try and limit it to only a few points. And I was actually given the mantle today to actually talk about some of the omissions which haven't made it to the amendment bill of 2022. But let me just open by saying, I think one thing which certainly merits a mention here is the collaborative approach which the CCI has taken in developing the jurisprudence and also the regulatory environment. And this is true not just for the amendments. And Jyoti ma'am would recall that we had such detailed meetings at the CLRC. And I mean, the amount of time and the amount of opportunity which the CCI offered to stakeholders, and I can talk at least on behalf of the lawyers, that effort was incredible, and which of course turned out into a great report. And now we are actually kind of reaping the fruits of all the hard work which took over, I think, almost over a year. So that's one. And I should also mention that, recently we have seen that collaborative approach also in relation to the amended confidentiality regime. And everyone was invited. I remember having a one-on-one on that meeting with Jyoti ma'am. And some of the comments, it's not, mere formality which is being done by the commission in the name of public consultation, but all of this leads to revisions, and the final draft which comes out and which goes for implementation actually kind of reflects that all the comments of the stakeholders have been taken on board. So truly grateful for that, ma'am, for keeping the approach absolutely collaborative. And we also get an opportunity to grow with the commission in terms of contributing to the jurisprudence. So again, we are grateful. Before I actually move to the omissions, I think there is one very specific point, and it's maybe a bit technical, but I must take this opportunity given I have the advantage of speaking with the secretary, and all of this is of course in the personal capacity. But there, in terms of individual liability under the Act, there have been some changes, although like the chair CCI also mentioned, Ms. Jindgar also mentioned that a lot of these amendments are reflective of the existing decisional practice, and also codifying some of the provisions which were either part of companies law or criminal procedure, and that has all been now brought into within the Competition Act / bill at this stage. And so you don't have to refer to another statute. So it's not really expanding or doing something new, but rather kind of codifying for more clarity and for more visibility in terms of Commission's existing practices. But in terms of Section 48, I mean, we all know that in case there is an individual liability which is identified by the Director General, and if there is a penalty which is imposed on an individual by the Commission, then we always referred back to Section 27. And the new amendments actually now have a provision of imposing a penalty based on personal income in addition to turnover. But an interesting amendment which has been brought in the Amendment Bill 2022 is also bringing in that penalty power under 48. So the initial scheme of the Act was that in case there is a contravention by the company and it is due to any personal liability, then the Act only said that the person is deemed to be guilty of that contravention. So if it's a contravention of Section 3, then the person is also deemed to be in contravention of Section 3. It could be Section 4. So you go back to Section 4. And for contravention of Section 3 or Section 4, the penalty was always under 27. Now, what happens as a result of the amendments which have been brought in Section 48, now the new regime says that in case the person is involved, then it will be deemed to in contravention of the Act. So it makes it a little vague. And instead of saying that he will be proceeded against and punished accordingly, it gives the penalty which is in tune with 27 penalty. But now there is a violation or penalty under 48. So which might actually make the regime a little complex, because I think all what was required under 27 is to have a clear provision to penalize on the basis of personal income in addition to turnover, which has been taken care of very well. But now, basically now Commission will have to pass an order under 27 and 48 together in case there is a penalty on individuals. And I think that is not something which was contemplated. Maybe these are some wrinkles which will get ironed out in the consultative and approval process over the next few months. But I thought it might be a good idea to just bring it to the table so that, bring it to the attention of the Commission. Another interesting change which I saw in the Act and which is not much talked about is that the word fine has been changed to penalty, and that is throughout the scheme of the Act. And that is very interesting because there have been some debates, there have been some court cases which dealt with this, that is it a quasi-criminal statute, is it a purely civil statute? And from a layman's perspective, I think there is very clear distinction between fine and penalty. Fine is punishment for a crime, and it could be punishment for minor crimes, maybe traffic violations or anything. And penalty is, more civil in nature, although it's kind of, it applies in the context of both civil and criminal, but it's basically penalty or punishment for breaking a law or not following something or failure to perform certain act. And in terms of punishment, so to say, I think the scheme of the Act has been more civil because there are only monetary penalties. And I think it's a very happy change to see that, the level of work which has gone into contemplating and discussing some of these changes, that the bill actually now calls every fine to be a penalty and not fine. And and now talking about omissions in the same breath, maybe I can actually talk about one proposal which made it to the 2020 bill but didn't make it to the 2022 bill, is the power to punish individuals for non-compliance of the DG directions by way of an imprisonment. And that was actually, that led to a lot of debate, that is it actually in the spirit of the Act that the Director General can get the imprisonment power when honestly the CCI does not have the imprisonment powers, because it's only monetary penalty until, of course, there have been consistent non-compliances, and then some proceedings will have to be initiated with the CMM, etc. So I think that is a very happy kind of provision which got dropped in the 2022 Act. And although I'm not certain in terms of the cap on the fines, because it was proposed to be 1 CR and 5 lakhs a day in the 2020 bill, but in the 2022 bill continues to be 1 lakh per day with a cap of 1 CR. But I think the whole tone and tenor is that, the message which is going out, and like ma'am mentioned, that the timelines on mergers has become so aggressive, amnesty plus, there are certain amendments which certainly give out very clear indication that commission is here to kind of promote businesses, and it's not with the intention of kind of arm twisting or try to be yet another regulator, which was a key concern when the Competition Act was being discussed. And Competition Act 2002 and enforcement in 2009, and the former chairs have actually seen a lot of this journey, that it was so difficult to get this Competition Act into enforcement. So another key change, which I feel is a very happy change. Now, there were a couple of requests which was made by the lawyers. I think one was a dedicated bench at the NCLT after a designated appellate authority has been dissolved and the matters have gone now to the NCLT. I think that was one important request, at least from the lawyer's perspective, that now we have a huge pendency of appeals. And to that extent, we at least requested that there should be at least one dedicated bench which could be designated solely for competition matters, because NCLT is overworked with companies Act work, with IBC work. And in addition to that, they also have to do competition. So, but that's one key miss to my mind, that if we got at least one dedicated bench, although, I mean, I am very happy with the way NCLT is functioning right now. It's tremendously efficient, the current bench. So kudos to them to actually put wheels in motion. Another, maybe, I don't know how important that request was, but there has been a lot of litigation in terms of having a judicial member on the bench. So that is something which has not made it to the bill, although, initial scheme when the competition law started had a scheme where you need to have at least one judicial and one economic member. And in the current scheme of things, we do have an economic member. But there was, given the kind of litigation which has taken place, I think there was one request that, that clarity should come in, that do we need a judicial member at the CCI? I think although in the current scheme of things, I think the bench has been performing quite well in terms of what's been done with 3-member bench, etc. But I think that was also one of the omissions which were discussed, at least in the legal fraternity, especially after the Mahindra Mobility case. But I don't really see that that is a big issue in terms of disposal of cases and in terms of the progress which has been made by the commission in terms of quality and quantity of disposal. Another important point which was discussed was also drawing some guidance from Europe. And in Europe, it has taken a long time to have some sort of an efficiency justification in case of abuse of dominance cases. And there were quite a few discussions which took place during the CLRC also. One was in relation to having some sort of an efficiency-based exemption, which is in at least in cases of agreements, there is a provision which takes you back to appreciable adverse effect of competition. So it becomes effects-based. But the moment you become a dominant entity and you do certain things, it becomes more of a per se approach. Although I tend to disagree on this, because the way the Commission's jurisprudence on AOD has developed, I think in most cases, Commission has given due regard to positive effects and pro-competitive effects. So although it may not have been codified to the extent people might be demanding, but in terms of the jurisprudence, I think the message has been loud and clear by the commission that they are not looking at anything as per se, and they're willing to accept and consider any pro-competitive effects or efficiency then, which is quite clear. And other issue which was interesting was that the IP exemption is only for Section 3. And when I talk about Section 3, it's more about Section 3(4), because vertical and dominance kind of become more akin to each other, and cartel is, like ma'am said, most pernicious form of violation. So we keep cartel in a separate bucket. But it's interesting that IP exemption, although it made it to the previous bill but not to this one, is that it's now only limited it to Section 3(4). But again, I mean, the fact that there are so many digital market cases where the commission got an opportunity to discuss FRAND terms and all of that. So in a way, I would still believe that it may not have been codified to the extent people expected. But in terms of, again, AOD jurisprudence, I don't see there is any deter for the commission to consider any necessary or reasonable condition which may be imposed even by the dominant enterprise to protect their intellectual property. So yeah, I see that, I am kind of running out of time. So I think these were some key points which I wanted to bring to the table. So, but again, I would re-emphasize the fact that there have been some tremendous efforts which has been taken both on the advocacy side and also on developing the jurisprudence. And like I said right at the beginning, that the collaborative approach which the CCI has adopted while developing this jurisprudence is exceptional, and congratulations to the CCI. And I'm truly grateful that in a way I could be a part of this journey and contribute to whatever extent I could. Thank you so much.
Thank you, Vivek ji. Thank you for sharing your thoughts on the bill, and you have shared your suggestions, which ma'am would have certainly taken note of, and we would request her kind consideration on the same. Thank you so much, ma'am. Now I would request our colleague Dr. Ravi Rathore, the Joint Secretary of PHDCCI, to give a formal vote of thanks and thank ma'am and the other keynote speakers for the day. Over to you, Dr. Ravi.
Thank you, Dr. Nasir Jamal. On behalf of PHDCCI, I would like to thank our keynote speaker, Ms. Jyoti Jindgar, ma'am, Secretary, Competition Commission of India, for sharing her valuable time despite of her busy schedule, and sharing the details and covering all the aspects on the Competition Amendment Bill 2022 to make the industry aware about the proposed changes to the competition law regime. I would like to also thank our chair, Shri Dhanendra Kumar ji, for setting the contest and sharing the details on the Competition Act. I'd also like to thank our co-chair, Shri Vivek Agarwal sir, for his concluding remarks and guiding us on organizing such knowledge sharing sessions with the support of Competition Commission of India for the industry to make aware about the new laws and the amendments and all. I would like to also thank Dr. Nasir Jamal, Secretary PHDCCI, for moderating the session, and all our delegates who have joined in for the session for their patient listening. I'll just have a request for our co-chairs, sir. The points you have shared, if you can share us on the document also, so we can take it up with the CCI for the same. With the permission of chair and approval of chair, so we'll take it up with the CCI madam, secretary madam. So thank you so much everyone for joining in, and we will not be going for Q&A session as we are already late for the time scheduled time. So thank you so much again. Thank you everyone. Thank you, sir.
Thank you, ma'am. Thank you, sir. Thank you, ma'am.
Thank you so much. It was indeed.
Thank you, ma'am. It was really wonderful, ma'am.
Thank you so much, ma'am. It was wonderful having you.
सर्कुलेट कर दीजिएगा इसको अगर हो सके.
Sure, sir.
Absolutely, sir. Absolutely.
We'll share circulate the recording of the webinar.
Thank you, sir.